Hi again. I'm Paul Ingbretson. I'm a full-time artist and a teacher of painting. I also served as a New Hampshire state representative for 6 terms, beginning in 2003. I'm one of a number of concerned citizens, including other former and current New Hampshire state legislators, who are very concerned about the unprecedented usurpation of legislative authority by our Supreme Court in the now infamous Claremont decisions of 1993 and 1997. We've come together to produce a series of podcasts that will lay out the facts and evidence for your consideration. We'll be hearing from some of the best legal minds in our state who have followed the issue from the beginning. Our goal is to create public awareness of the serious separation of powers implications of the Claremont decisions with the hope of generating active public resistance to it and any future such judicial overreach. In our podcast today, I'm joined by both Rick Lehmann and Greg Sorg to respond to audience questions arising from the previous 2 podcasts. This is podcast 3 covering the Claremont decisions. We are trying to create awareness of what those decisions were, why they were, in some of our opinions, unconstitutional and certainly destructive of the rights of the people by the look that we have, that some of us are taking. And I don't want to put any of you guys precisely in that position. I'm not phrasing it that well, but the idea is, though, to create enough information for the public, and if you are following all this sort of stuff and believe that this is something that you want to take control of again, get the House to have, the whole general court to have control of again, we're trying to create what I'm calling a tailwind, so you need to call your reps and do all those things. But we're going to keep doing these podcasts, including possibly an interview with Van Loan, who you guys have just mentioned. You mentioned him too, I think, in your comments. But I'm going to ask you a question from Van Loan, and then I'm going to ask these guys questions. But because of the way things have worked out, this is really an opportune time. If you hear other things you want to ask questions about, I'll actually have you ask them from out there, or even to clarify some of these, but I'm going to read them first. And if we can do it that way, it'll probably be more efficient. So do you agree, this is the question, do you agree with the idea that, to quote Van Loan, that the judiciary's authority to determine questions of constitutionality is legitimate, exclusive, final, and supreme? I love that. The judiciary's authority to determine questions of constitutionality is legitimate. Is number 2 exclusive? Is number 3 final? Is number 4 supreme? You guys have any commentary about that?
I don't. I've never bought into the idea of judicial review because, as I said when I spoke before, why would they write opinions? If it's just a matter of you win, you lose, that's all they would need to say. But they write opinions. They write opinions for the purpose of showing that their opinions were properly based in the law and not on their personal preferences of the judges. And if they write the opinions, as legislators, you ought to have the right to review them and see whether they've passed the smell test. And if they don't, the legislature should be able to disregard them.
So they're not final. The final arbiters. I mean, it just keeps looking like a judicial oligarchy to me when they start doing things like they're deciding what things the general court ought to do.
And I would refer people to Andrew Jackson's veto message of the bank bill, which spells out clearly why this is so, that judicial opinion are only entitled to as much deference as the quality of their reasoning deserves.
Yeah. Do you have any comment on that one?
I guess I'm a little more comfortable with judicial review as a concept than Greg is. He's a better historian than me, though, so I'm sure his review is correct. But we've had judicial review for a long time. It's sort of woven its way into the fabric of what we have. Somebody needs to be the last word on what the Constitution means and how it applies to individual situations. What I don't think that means is that the fact that there's judicial review doesn't mean not all judicial review is created equal. Okay, an adjudication of a criminal case in which police conduct is being challenged is an appropriate thing for them to do. And to declare, if they declare that a search is illegal, then the consequence by court-created law is that evidence obtained in an illegal search is inadmissible against a criminal defendant. I think that's a system that works pretty well for us. It's a system that has a lot of judicial review more broadly, has a long historical tradition in the country. I think it works out okay. I don't think it means that they're the only people who get to have an opinion about what the Constitution means. They don't own it. lawyers don't own it. It belongs to all of us, and it belongs to all of us equally. It's not a lawyer's document. It's not a judge's document. It's a people's document. And the judicial branch, I believe, undercuts its own credibility. And I think it's important to maintain judicial branch credibility as part of our system. I believe in it and want that to be the case. But when they go wrong, I think it's incumbent on them to try to adjust and repair and fix things. Just like the United States Supreme Court went wrong when it said that separate but equal is still equal. I think that's wrong, and they later on corrected it. And I think that our court should correct its claim that the very broad language in Part 283 of the Constitution that requires the legislature and the magistrates to cherish education imposes an affirmative duty to identify and pay every last dollar through state funds of what into a system that the court determines supplies educational adequacy. I think that they don't help themselves by sticking to that position, and we'd all be better served for them to recognize that they don't have any special capacity, ability, or knowledge that will enable them to determine what educational adequacy or what the proper amount of cherishing is.
Yeah. Well, the reviewability question, and this is just me now talking, why shouldn't the general court have reviewability over the court's decisions? The general court, us. Why shouldn't we have reviewability, and don't we? Because you're saying, I mean, it almost implies that you're saying they really do have final authority. Somebody's got to. I don't know that it shouldn't be the people in a representative republic.
Well, they have final authority over some things. When the people put rights into the Constitution, they're taking it away from the legislature to some degree. And saying these are things that are outside of the scope of proper legislation. 51% of the people cannot deny 49% of the people these rights just because they have a legislative majority. That's appropriate. I just don't think that's not the model that this education provision sets up for us.
Right. So this is the reviewability of that for us.
Right.
I think, to me, it seems like a big deal. I'm not going to push it. I want you to be able to get out of here safely. This is just from you guys now. This is not about education or how much is spent, but about who pays. I'm not sure, are you looking for a response on that one, somebody?
Yeah, so that was my point, I guess, or possibly question. But this is not, because they didn't say how to teach or how many kids in a class or all this kind of stuff, right? And none of their decisions hires any teachers or fires any teachers, right? Or hires any administrators or fires any administrators. So the amount of cost of the whole thing is fixed. This is all an argument about who is paying that cost, right? Is it the people in Moulton Borough, the people in Concord, the people in this, that sort of thing, right? Would you agree, I guess? Would you believe?
Isn't it true that? Yeah. I do think you're right that the foundation of the Claremont cases lies in taxation more than it lies in education. And that's frustrating because we talk about education, but the cases are really about who pays, exactly as you say. And it raises this interesting question for me because courts are slow-moving creatures and tend to lag behind the broader culture in a lot of ways, and so they've created the Claremont dynamic based on a system that assumes that the overwhelming vast majority of children go to the public school in the districts in which they live and in which they pay taxes, and nationally, not just in New Hampshire, but including in New Hampshire, our view of what an education should look like has changed a lot. And so, there are people over in that building talking now about universal backpack ed funding, where the state just gives money to families and says, go out into the marketplace and get an education that you think fits the needs for your family and your children. That really is kind of inconsistent with this whole Claremont dynamic where you identify what goes into it and you cost it out and you obligate people to pay for it. So if the state, and this is just a hypothetical of course, but if the state were to give everybody a check, I don't even know how you determine whether the educational adequacy that the court has required is being being met or approached or anything. But at the same time, I think that an awful lot of people would agree that that's the best situation for their families. I know a lot of people feel that way, not everybody, obviously. So it's sort of, the court runs the risk of its Claremont rulings becoming locked in amber and unchanging, and sitting there in a world in which everything around it is swirling and changing very rapidly. And it just gets in the way of education reforms, education experiments, all sorts of things that might be beneficial for the state, because we're locked into this per pupil, per district structure.
Did you want to say anything on that?
Yeah, I agree with that entirely. At the time of Claremont 2, I recognized that what the court is doing, whether consciously or not, is constitutionalizing an education paradigm which was already becoming obsolete. It worked well in the 19th century, well into the 20th, but it's not really working anymore, and yet here they are, they're pretty much locking it into the Constitution and stifling creativity while the legislature is doing what you said in your remarks. They're chasing around trying to comply with the rulings and not focusing on the real question here as to how to get the best education possible for the school children of the state.
Keeping us from cherishing it properly. So you said that the legislature should determine education policy, but should it really be school boards? I think that's shouldn't it really be school boards? Do you guys have any comment on that?
I'm really agnostic on that. I'm focusing on who makes the decisions, not what decisions are made. And the decision should be made by the legislature, free from interference by judges, and that's
that part.
That's the extent of my involvement.
This question was, you said that, right? So the legislature should be higher than the judges. But what about the school board? Should the school board be making these kind of, how to teach kind of decisions, and not the legislature?
Well,
Article 6.
It appears to me the way things are developing in this ongoing saga is that any school board in the state that thinks it's not getting what it thinks it ought to get has standing to bring suit and raise the financial stakes of litigation. They're driving the costs ever upward, because we have to, if we satisfy the most unsatisfied school district, then the other ones are going to want more too. It's just a never-ending spiral upward of costs.
Did you want to comment on that?
I guess what I would say about school boards is I find myself in litigation with school boards quite a bit. Most recently over here in Bow. But the school boards are like towns. They're creatures of the state, and they have exactly whatever authority the legislature gives them. And the legislature can take all that back and say this is how it's going to be, or the legislature can delegate choice to the school boards. And that's a system that works out pretty well, though I will say that the potential consequences of these cases that are pending now, and the financial hit that they may impose on the state, frankly, if the plaintiffs get what they want, may very well result in a real revolution at the structure of education in New Hampshire that undercuts local school boards to a great degree, because a legislature that's required to pay every dollar is also going to want to have control over every dollar.
Yeah.
And so if all the money is coming from the state, then there are school districts, single school districts that encompass populations greater than the state of New Hampshire, 1.3 million. And we could find ourselves with a single statewide school district with all local educational decisions being run out of Concord, which I think would be very dissatisfactory to a lot of people, and for good reason.
Yeah.
And as I said in my remarks earlier, that seems to be what they are asking for, not realizing that they are, in effect, going to destroy themselves if they get what they want.
Yeah, well. What if we just repealed, was you talking about 1966, or was it the amendment 72A? Was that the one you were asking?
Yes.
28A, or 72A.
72A.
The one in 1966 constitutional amendment that basically gave the courts higher standing than they had before.
Yeah.
But if we just repealed that?
Would that be helpful? And is it even doable?
Yeah, I don't think it would be
I don't think it would change
doable
much.
anymore.
And passing a constitutional amendment. Well,
Yeah.
we've done it.
We've done it.
Yeah, 72A made the Superior and the Supreme Court's constitutional court so they could no longer be uncreated by the legislature if they misbehave. And the other thing that was done in 1966 was the grounds for removal of anyone by address was tightened up, so they get to have a hearing. Now, it used to be a very simple process. I even brought materials along to demonstrate how simple the process of address was back in the 19th century. Very easy. It didn't require any participation at all by the person being addressed. Just the legislature passes the resolution, takes it to the governor, he shows it to the executive council, they sign off on it, you're gone. There was no participation by the addressed person. But now 73A, I think it was, amended 73 amended the address process so that it has to be for reasonable cause, and the person being addressed has a right to a hearing before the legislature.
Would that work?
Well, they were passed at the same time. They ratified at the same
But I
time.
mean, if you just repealed 72A and left 73A stand.
So that the legislature once again have the authority under Article 4 of Part 2 to create and therefore to uncreate courts. Yeah.
It's still there? You're saying it's still there? Or are you saying that's what repealing would do? Would bring it?
That would take us back to
Yeah,
the
okay,
pre-existing process.
So my only point to you guys is that you got enough to rabble-rouse. See if we can get Claremont. We'll see if we can get this fixed just at the house.
Obviously,
That's our first goal, I think.
Steps, right? That's what we can
exactly.
do this year and what we can aim for. And so that was can we aim for that? Does that even make sense, or would that put us?
Oh, bring in bills like that,
backwards somehow?
sure.
See, my thesis is if the legislature were to find in one case, being Claremont, that the courts went too far and just refused to enforce their decree, that would have such a chastening effect on the judiciary that we wouldn't have to bother doing these other things. They would say, okay, we went too far, we'll behave ourselves from now on. See, now they don't have to be circumspect because they've been getting away with stuff for years. Back in the 80s, in the pre-computer days, we would get these stacks of paper each month of the decisions the court rendered, and I noticed a pattern in them that the court was, poking sticks in the legislature's eye by calling this, that, and that thing unconstitutional. And I thought, what are they up to here? Are they seeing how far they can go before the legislature will squawk? And apparently they were, because by the time Claremont comes around, they took that gigantic step that I was wondering if they were going to take and upended the education system. Because there was no blowback. There was never any blowback from the legislature, and so they thought they could do anything, and they overreached. And if we were to draw the line and say, oh, we're not going to obey this, then they would be chastened, maybe for a generation, but before they start doing it again.
Is that a plausible thing to think about in the Senate, for example, to get that
I
kind
can't
of...
speak for the Senate. I don't know.
No, but from what you've seen in terms of whether energy lies or any of that kind of stuff, does it seem like...
it's a different group every year.
Well, that's true, yeah.
So yeah, I think I would be overstepping my bounds to sort of predict what senators might think or do in the future. So, but I do think, so obviously people have gamed out what happens if the court makes an order that isn't complied with, and how does that go? And there's been sort of a lot of talk about that through the years, and uncertainty is not great for a functioning society to not know what's going to happen next. So the idea of upending centuries now of traditional adherence to judicial orders it's concerning to think about where that might lead, but at the same time, I don't know. People who get elected to the legislature are going to do what they're going to do.
Yeah.
You can lead a horse to water, but you can't make him drink, and you can make the order, but they can't appropriate the money. So only the legislature can make the appropriation, and
and there's this duly...
It always comes down, I think, eventually, and I'm glad it does this, to voters. Because the problem with Claremont is the court has gone to the point where it's ordering things that the voters just simply don't want. The implication right from the start when I read it in January '94 was we're going to have a state income tax or sales tax to be able to comply with this, and the people are not going to do that. And so the legislature's caught in the middle between the court ordering things and their constituents not wanting them. And so when the Claremont advocates, the school districts, complain about the legislature being intransigent, it's not the legislature, it's the voters who are being intransigent. That's a good thing, I say, right on.
So does the question of Grimes that came up, Grimes being ineligible to be a Supreme Court thing, is that a thing, for example, that the legislature could use to disqualify that?
Did he participate in a decision after he was 70 years old or something like that?
Yeah, he was a substitute for Thayer in the first
Claremont.
Yeah,
right.
yeah.
I don't know how you go back and do anything about that 30 years later.
Oh, right. I guess that's an issue. Yeah. But on the other hand, though, it's a factor now for us. We're suffering from it. So isn't it an ongoing
But
injury?
it wasn't a decisive vote in a 3-2 court, right? I mean,
No,
it was
right. It was 5-0.
5-0 the first time, and then 4-1 in Claremont too,
Yes.
right?
Yeah, Horton was an exception. Yeah.
So, I mean, in the law, there's a concept of harmless error. So even if he participated, there still would have been 4 votes.
Well, that's
Even
right.
if Grimes hadn't
Yeah, that's a good point.
participated,
Yeah, that's obviously a good point. But no, the question, though, is still, does that legitimize or does it not legitimize the fact that there's actually an unconstitutional behavior that went on in the course of making that? I'm just wondering, as lawyers, you wouldn't even go near
It raises an eyebrow, and I tell you, for interest,
Yeah.
I had a couple of high-profile cases pending in the Supreme Court last year, and I did the oral arguments in the summer of 23,
Right.
and then Judge Hicks retired because he hit the age of 70 in November. My cases were still pending. So I'm looking around saying, wait, he was there. Can he participate in making the decision, or is he off my panel? And he was off the panel. He didn't participate in any of those decisions, even though he had been involved in the case and participated in an oral argument, and given it to me pretty good.
Yeah.
He wasn't part of the decision.
Yeah. Well, that gets to the other question that one of the other ones that Dan had, that Part 2, Article 83 mentioned seminaries, literature, science, and all these things. Has the court ordered the legislature to fund authors, artists, scientists, and seminarians?
Well, seminaries would be
In the
particularly
class of
interesting to have a court order payments to religious institutions, right?
Which is why I always argue it means that's not what cherish means, because that's in the same thing, and no argument has ever come about not funding seminaries, and therefore cherish can't mean pay for.
Right. I think that's an excellent point.
I think I covered those contradictions in, I think, my objection to the motion to strike, in which I point out some of the other things that the Article 83 has that the court has conveniently not afforded the same protection as cherishing. Now, there are other verbs in there too that are just as yeah, that are just as obscure, and is the court going to find substantive rights hidden in those? And one of the, I point this out in that pleading, I remember, one of the things to be promoted is sobriety, and I ask, how is the state operating a liquor monopoly consistent with promoting sobriety? Serious. 83 is full of things to bring up.
Monopolies would be another one.
That's right.
Yes,
That's right.
absolutely.
It's a monopoly.
Big deal.
Well,
Question from
while you're on,
Greg. Yeah.
While you're on 83.
Go loud, though, so we can pick you up.
While you're on Article 83, can you speak to the fact that the New Hampshire framers decided to change the one word legislature to legislators and the significance of that?
From the Massachusetts to the...
Yeah, I've thought a lot about that. In fact, one reason I thought about it was when we were trying to find a way to get into the court in the Conval case. How do I justify filing an amicus brief? And I used that distinction because I couldn't do it on the basis that the legislature wants to participate by way of amicus, because I couldn't speak for the legislature. I wasn't commissioned to do that. But because our Constitution says legislators and the duty impacts on legislators, I can get some legislators together and make a case that we should be able to participate. So I use that distinction. To me, it's a significant difference because the Massachusetts Constitution in the parallel provision says legislature. Ours says legislators, and I think it was done deliberately because if it were the legislature, there would be more of a case for the court determining what they are required to do. But if it's legislators, it's more of a responsible. More of a moral duty.
Hortatory.
Because how can a court dictate to individual legislators the content of their duty? That's what we're elected to do. We're elected to exercise our judgment. I keep saying we as if I were still in the legislature. It's a
You are. You're still honorable.
But yeah, so far
I think
they haven't found me out yet.
I think that's, in a lot of ways, the most important point about sort of the distortion that I came here to talk about, which is that, was it Thomas Sowell who says there's no choices, only trade-offs, right? And so by saying the legislature has a constitutional obligation to cut a check and pay money out, puts that on a higher pedestal than all the other things that legislators have to balance. It would be really nice for everybody to have all of everything they wanted. But of course, scarcity is sort of iron rule of every society, really. There's just not enough of everything to go around to satisfy everybody. And so legislators come into this building for the $100 a year and have to make trade-offs. And, the courts, the way the Claremont decisions have gone, have basically put education outside of the trade-offs that everything else in society that the legislature touches are forced to contend with. And those trade-offs are hard, but saying that education's not part of the inherent need to have trade-offs is just a huge mistake, and it distorts the way they go about their business over there.
What bothers me about this is that it doesn't seem like that we have what would you call that kind of a need to have a legislature. The way their thinking works. Where's the real need for you guys to even sit there and figure stuff out like this? We'll tell you. Anyway, that's the question. This is the beginning of the administrative state, someone is asking.
What's the question about?
Is this the beginning of the administrative state?
Oh, we've already got the
Hardly
administrative
the
state. It is here and healthy.
Oh, gee. You want to say more of that?
Well, there's no other way to do it, really. The question is, and certainly when the Supreme Court abandoned Chevron doctrine now, how much authority the administrative agencies have is an excellent question to stay on top of.
Yeah.
And requiring, and we have a process here that requires administrative agencies to come back to the legislature before they adopt their own rules.
Yeah.
They don't have that quite the same way in the federal system, but that keeps things a little bit in check. My beef with the administrative state has to do with when people who are regulated entities are facing some sort of sanction, and they have to go in front of an employee of the head of the agency that's imposing some sort of sanction against them, and they treat that like it's some sort of fair and impartial court, when frankly the administrative judge that you're hearing is drawing a check at the pleasure of the head of the agency. It doesn't leave people feeling like they got a fair shake.
Yeah, it used to bother me a great deal when the first people you'd hear from was the administrators. No matter what the bell is, the first guy's in the room, right? Well, what's that all about? But that keeps us there. That's how important they are, I guess.
Yeah.
Huh?
Sidelight, though.
Let's see if I have left anybody else. Did somebody want to know what bodies corporate means? I don't remember what context that came up.
It's in Article 6, Part 1, right? And it's bodies, comma, corporate, when I look up the text, and maybe that's just a typo in the digital version. But
I think it was bodies hyphen.
not
Corporate.
when I
No?
have looked it up a number of times.
There you go.
And so then what does that mean? That means municipalities and school districts, and so why don't...
And the Housing Finance Authority and P's authority, anything that the legislature created is a body corporate in politics, basically. And there are laws that allow you to create your own. You can create an LLC or a corporation or whatever you want under state law.
Well, Greg gets that.
Where is it?
Is that the original?
No, it isn't. This is taken. I think this is taken
It's hard to
from
read.
the pamphlets that they hand out here. I have, because Dan Itza sent it to me, a copy of the original journal from the 1792 convention, which has the whole Constitution in it.
Right.
But I didn't bring that with me, so.
Okay.
But I'll look for that,
Well-
see what it says. But I assume they're just meaning corporations, just
Could be anything.
bodies, corporate.
You've been talking about Conwell. You both have any comments on the Rand case? I don't know what that is.
The Rand case is the tax case that goes along with the Conval. They're separate cases. I haven't been as involved in that, so I'd probably be speaking out of school.
Isn't the first canon of law that no one can be judge in his own cause? If so, how can it make sense to ask the court to rule on the limits of its own power?
Yeah.
E.g., judicial review itself, again. That is, Marbury and Madison, right?
Yeah.
No, that's the dilemma you get into when you created the judicial independence, that they become the judge. I mean, who guards the guardians? That's the famous
Shouldn't they guard
phrase.
each other? That was my question. Shouldn't the legislature be the judge of the judiciary if the judiciary is going to be the judge of the
Well, there's supposed to be
legislature?
checks and balances, but as
Right.
I mentioned, we've frittered away all the checks
Right.
against the judiciary.
I mean, it always reminds me when people go, oh, we'll go to the government. And first of all, they act like the court is not part of the government, which it is. And the second thing is, we'll ask the court to rule on the limits of its own power, which is sort of like, I don't know if you know, recently the FBI investigated 7,000 shootings of their agents and found no mistakes. None. Zero.
Surprise,
So that,
surprise.
it seems like something that we shouldn't let slip by.
I think you raise a good point, especially about the boundaries of judicial legitimacy, and they may have a different view of it up there than folks do down here. I think that when you read judicial opinion, you read them saying the words of caution, and they have restrained themselves. The last couple of years, they were asked to claim a right to determine when legislative redistricting was an impermissible partisan gerrymander, and they said we can't do that. What do we know? That's super political. It's nothing we know anything about. It's outside our brief. We're not touching this. And my view is that's what they should have done with education from the get-go, and what they should do with education funding now is to correct it. But they're aware of their own limitations, and at times they make pretty valid efforts to avoid overreaching, because they know it'll hurt their legitimacy and their standing in society. For the most part, I think they do. I just think they've made a mistake in this one area.
Yeah, I think maybe the blowback they've been getting in Claremont, even though the decisions haven't been repudiated by the legislature, at least it lets the court know that they've gone a little too far. They've bitten off more than they should chew, and they're pulling back a little. So it's having a chastening effect. Nevertheless, it reminds me of the impeachment imbroglio of the turn of the present century, which ultimately supposedly failed. But being a person who was in court more in those days, I know it actually was a victory, because judges became much better after that. They became much more courteous in court. It was noticeable. There were some arrogant people, even up in Grafton, that you wouldn't want to go before. They were so rude. They were so abrupt. It's not like that anymore, at least not up where I am. And I think the efforts of the late Paul Mirsky in bringing David Brock up to the court had an effect of getting the court to clean its own house a little bit, which has been an ongoing benefit to all of us.
And so you think that, I think you said this, that the sort of one slap on the nose by saying we're not going along with Claremont.
That's where I think it would go. I know
there is no need to articulate a principle or amend the Constitution to say there are limits, or we're all
one
equal.
repudiation I think would do it. Now others think one repudiation and the whole house comes tumbling down. Oh my God, the legislature is going to eviscerate the courts this way. But I don't think it would happen very often. I think the legislatures know the gravity of doing that. And so if they did it once, they wouldn't have to do it again for a long time, because the courts would behave.
We're in a state of confusion right now, aren't we?
Well, we are. You might say we always are.
About roles. Well, yeah, but there's been more clarity in the past.
I think
Hasn't
it's
there?
fluid
Yeah.
and it ebbs and flows.
Yeah.
I do think, well, I don't know. So, I mean, it's interesting. The question arose sort of like, who's the superior branch? And sort of one of my pet peeves is this idea of 3 co-equal branches, because I don't think there are co-equal branches. The legislative branch is supreme. The court can pass on the constitutionally of legislation, but the legislators always have the power of the purse and the power of impeachment. I don't think anybody up there right now ought to be impeached, because none of them participated in Claremont 1 or 2. We have
That's right.
5 justices had nothing to do with either of those cases. So they inherited all this mess
Yes.
in a lot of ways, or the current group. And the question is what they're going to do with it.
Yeah.
And I don't think it would probably be an impeachable offense to apply precedent. But it's always up to the legislature to decide those things. But that's the ultimate sort of act that the legislature has at its disposal to rein in the court if it feels the court gets too far afield.
Well, I think a part of what you guys are doing right now is going to enable them to see that we're interested in whether they're going to keep doing that, something we consider to be egregious.
And I did remind them in the brief, of my 2020 brief, that nobody on the court now was on the court in '93.
Yeah.
I didn't say it in just these words. I said, do you really want to have this headache forever that was bestowed upon you by those lawless people back in '93?
Yeah.
I asked it more nicely, more lawyerly, but that's basically what I said. Why do you do this to yourselves? Why do you keep hitting yourself? Like my
And why do they want to do that kind of work?
grandchildren.
That's what lawyers like to do, is it legislate?
Well, it's not. And again, it goes to my point that because they're not able to do the work in terms of they can't measure, cherish, or adequacy, they are ordering the legislature to create the constitutional standards so that they can come back and apply it later.
Yeah,
And that's exactly what's happened.
Yeah.
Now that they've ordered the structure's been put in place.
Yeah.
Now they have something to weigh it against. Now I don't think it's not very satisfying when they compelled the thing in the creation of the standard in the first place.
That's
It's not-
legislative.
Right.
That's
what they've done is say, what you're doing is unconstitutional. And when we ask, well, what's constitutional? Well, we can't tell you that. Come back in a couple of years and with something else and we'll let you know. That's what's been going on. That was like Richard Nixon's secret plan to end the war in Vietnam. Remember that? What is your plan? Well, I can't tell you that. You'll have to just elect me to find out.
As if I have one or two more. I think we're at the end, close to the end of this. Does somebody have one I've missed? Question that I've missed?
I do have a
Yeah. Go ahead. No, go ahead.
Question.
I'd rather you keep doing live. Yeah.
So, and I've heard all of you talk about this. You sort of use the word constitution and court slightly interchangeably, and I find this interesting. I mean, I have heard you, whether you meant to or not. And I mean, do you think a court decision is automatically a constitutional amendment, even though the Constitution itself hasn't changed? People refer to it all the time, lawyers in particular, the constitutional decision, or whatever. And it's like, what do you think about that?
Court decisions don't change the Constitution. And I think Greg and I both wrote about, and Jean Van Loan, who was mentioned earlier, wrote about the fact that when you read these Claremont decisions through time, the degree to which they refer back to the Constitution constantly decreases, and the degree to which they refer to their own precedent increases.
Yeah.
And so and the problem with constitutional adjudication is if you have an error at the very beginning and then you keep relying on it, it just spirals and gets worse and worse. If the sooner you go back and lance it, the better off you are.
My question is, why isn't that a kind of a cool thing to do, to go back and fix something that big? Why isn't that just as important as what?
I think it
What
probably
is it? Yeah.
comes from the House to some extent, and it's because of this, and you know this, and you know this. Anybody who's ever served in the House knows this. Whenever anybody proposes an education funding formula, the first thing they do is create a spreadsheet. And they hand the spreadsheet around, and every legislator looks at how it affects their district, and most of them vote accordingly.
That's true.
Because that's the dynamic that applies, it's very hard to get the supermajorities you need to do a lot of these extraordinary things like pass constitutional amendments. Everybody wants to know how it affects their wallet. And that's normal, that's reasonable, that's the way it's always been. But to get a legislator to vote the school district in their town less money would be quite a trick.
I know that one. I was there. But what I'm asking is, why don't the courts suddenly see this as an opportunity for them to do the heroic and the unusual, like the Roe versus Wade thing?
You think that would?
I mean, like
you think
a really
they would
cool
see that
thing.
as enhancing their prestige?
Yes.
Instead, they go
Yes.
the other way. They say that admitting a
Independence.
mistake will hurt our prestige, even though the
Yeah.
mistake is so plain to see. I don't
Yes.
understand that way of
Adverse
thinking
and
either.
close.
I think there's also a tendency to say, and I have no idea what the personal lives of judges is like, and I have the
No.
slightest idea, but they're human beings. They're affected by peer pressure and the recognition of their friends and neighbors and colleagues the same way all of us are. And it's a lot easier thing to take to the public to say, I support public education,
yeah.
and those people who want to do something differently don't.
Yeah, but we're out here, even on the street here, we're at the level of saying, that's not their job.
It's not their job, but I think
we on the street get that. So
Yeah.
aren't they going to be heroes?
I think that there's an equal chance that that in their peer groups will see them as villains
Yeah.
because they
Yeah.
deprive New Hampshire children of education.
You guys would know.
I'm trying to help them screw up their courage by in the memorandum I filed,
Yeah.
showing this is what the U.S. Supreme Court did in the Dobbs case, and look, they did it, and the world didn't come apart, and you guys are still functioning, and
Yeah.
so
And the
why
states
can't you
got their
take-
rights back again.
Why can't you take some courage from that and do the right thing?
Yeah.
It won't hurt a bit,
Yeah.
and reverse Claremont 1 and 2. I'm trying to get them to take that route rather than to just stubbornly cling to their precedent because they don't want to be perceived as not being omniscient.
Yeah. But to have to keep on doing things that look like legislation, even when they know that's not what they really like to do.
Or ordering other people to legislate.
Yeah, well, that's the same thing, isn't it?
It is.
Yes, please.
So
Yeah.
as a way of dealing with that, something that's occurred to me for quite a while now is we always put judges on the bench, or lawyers on the bench. And here's the thing, the training of a lawyer is not to look at a declarative sentence and determine what it means. The training of a lawyer is to say, I'm going to look at what's written here and try to make it mean whatever I want or whatever my client wants it to mean, which is the
Ambrose
worst.
Bierce.
It is the worst possible training for somebody who's supposed to say what the law means. And I mean, the legislature could actually say, you know what? No more lawyers on the bench. And everybody would have to go back to the Constitution instead of going through 600 pages.
Could you hold that for a second? Could I answer him first? Bill O'Brien and I put in a bill in the House to say that the number of cops, for example, this is an example, the number of cops on safety, what is that, the department that they tend to fill up, the number of educators in the education committee, it can be only commensurate with the number of those people that exist in the society. It can't be any more than that. Well, Greg or somebody had a great idea that should actually be in rules. I forget who said that, but we could put that in rules, and we should. But I'm saying that was it. That was just totally thrown out the window. That didn't get anywhere.
You gotta start
So-
and keep going. You can't just end after one.
No, well, that's right. But that's why I'm here doing this now. Well, you guys should answer that, though, if you don't mind.
When I was in law school, I noticed,
You can remember it.
I thought I perceived a subliminal, maybe a not so subliminal message, because we study law
You
in
need
law
to get
school
out of
by
it.
cases. We do by the case method. You read cases and then discuss them and
It's good stuff.
learn through them. But the subtle message of this is that judges are these wonderful people who fix up all the screw-ups that those dumb idiots in the legislatures create. And so it does create a class of lawyers, I'd say, a mindset to worship judges and find no fault with them.
I mean, Justice Scalia, in one of his books, actually has this great passage where he talks about how law school trains people to see the great lawyer is the one who runs around precedents and stiff-arms definitions and literally makes a football analogy until he gets to good law by ignoring things like statutes and precedents and common sense. And that's the thing that worries me, is that's great training. If I am hiring a lawyer, that's what I want, right? I want a guy who's going to be It's like the old joke about, like, a good accountant will tell you 1 + 1 is 2, a bad one tells you 1 + 1 is 3, and a great one says, what do you want it to be? That's how judges
Yeah,
are. I think
yeah.
that's how, and if you've got a lawyer...
So that's not good for the Supreme Court, is what you're saying.
Right, that's great if I have a lawyer, but that's not what I want. Somebody to read the law and go, it says no law abridging freedom of speech. Oh, does this law abridge freedom of speech? Was it passed by Congress? Okay. And then you don't need those written decisions because it's obvious to everybody. the written decisions are there because you need to tap dance around what's obvious and come up with a conclusion that you've now justified by looking at precedents, by doing whatever, by turning words on their heads, by saying, well, no doesn't really mean no. Sometimes no means some. Right?
Well, that's what happens a little bit, isn't it, here? In that whole thing about adequacy and cherish and all this stuff. I mean,
Well, they certainly, adequacy isn't in the Constitution. Accountability is not in the
They found it.
Constitution. Well, so I think I largely disagree with you. I'm part of the lawyer guild. I admit it, and won't hide from it. So I'm definitely a creature that's been molded by 30 years in my environment. And for the most part, I see judges trying to pretty hard to reach the result that the law requires, and that is justice. And in this case is sort of interesting because it's so exceptional. Most of what they do is grinding out regular disputes between two people and applying regular legal standards, and it really is
Utility rates cases.
sort of hard work. And
but is there a difference between the Supremes and the general mindset and what they ought to have? Is it different from
even then, if they're reviewing a divorce decree or something, I think they try to apply the law. I think that what happened in Claremont, starting in 1993, they started applying case law from other states to reach a result that apparently somebody thought would be beneficial or that's required by the inclusion of the word cherish. I think that was a mistake from the jump.
But I think both of you, if I'm not mistaken, would agree that they decided the result they wanted and then backfilled.
That's what I think, yeah.
There was no idea that I'm going to look at what's in, I've got Article 83 and it says I can't create a monopoly and I'm supposed to protect the inherent and essential right to competition, so I'm going to create a monopoly to destroy competition, right? You don't do that if you're starting from what it says and seeing where it goes. You do that by saying, I want to arrive at this answer. I want the state to pay for this, and I want this to be required, and now I will just grab whatever I have to make it look like it's justified.
Yeah.
Now, whether they did a good job or not, whether that was the right decision, I find it hard to believe that they went through any other process than deciding first what the answer was going to be, and then deciding how to justify it.
I think they wanted a broad-based tax, and they saw this as a good vehicle to get there.
Well, certainly there are those who are still doing the same thing, and you can explain to them why it's unconstitutional and why that's not what cherish means, and they don't care because they want the broad-based tax, and that's their end goal, and they don't care about any argument in between. And that's what I've been 6 years arguing about. So.
I have two more, if you don't mind. You want to make a comment?
Well,
on that?
I'm reluctant to attribute motives to people and why they want to do things. I wasn't inside anybody's head when they were reaching those decisions, so I don't know the analytical theories they worked through.
You should have written them down, right?
Yeah. Well, they did. There, or at least at the very least, they wrote down in Claremont 1 and 2 the final conclusion, right? What the justification. Now, whether that's the actual analysis or not, I don't know. But in terms of whether, I've known some of the current batch of judges before they were Supreme Court justices, and I don't have any reason to think that there's a strong feeling up there in favor of a broad-based tax as a political outcome. Certainly nothing I've seen.
No, I was referring to legislators, not judges.
Oh, okay.
Is there a strong feeling up there that they favor public school systems as opposed to private schools or charter schools or pod schools or home schools?
I don't have any idea.
Well, there's a question here.
I think that's embedded in Claremont 1.
Yeah, that's something else the court now is stuck with, is what the motives were for the 5 wise men of 1993 when they were deciding to use, if I'm correct, I could be wrong about it, but that's just how I perceived it. They just wanted to force the legislature to have New Hampshire enter the 20th century and use the public schools as a way to force that, and they just went a little bit too far, and they run into massive resistance, which they didn't anticipate.
I have two more questions that come both from you, Dan. Is there one, or you have one that you'd lay? Okay. New Hampshire is the only state with these. Is not the only state with these kinds of lawsuits. What's happened elsewhere? and who's behind it, but that's the other one. But what's happened elsewhere? Because you at some point had said that was a multiplicities of these things going on that looked awful like each other.
Massachusetts really pulled back in its case. They had their Claremont equivalent case. The legislature went to work, did a lot of changes. The legislature here has done a lot of changes, and they pulled back from the brink and said, "Okay, we're out. This case is dismissed." Yeah. Our case, early in the Claremont years, I consider this sort of post Claremont now because Claremont's not a party anymore. But right. One of the problems with the way our case law developed is that they just held on to jurisdiction over these cases, and usually courts don't do that. They decide the case and they send it back and they say, okay, well, they wash their hands of it, and I've done my job. With the education law, with the education funding cases, they've just held on to them and say, we're going to keep an eye on what's going on down there in the Gold Dome building and see if it's satisfactory or not.
Other states,
so we can act.
You know of other states?
Did they overrule their?
They didn't overrule it. They just refused. They said they dismissed it and said it's time to extend in Massachusetts, I believe.
Because that's another feature of Claremont that is unfortunate. They basically deferred to the Supreme Judicial Court of Massachusetts in their school funding case. Because as you know, our constitutions are very similar. They have their counterpart to Article 83, they have their counterpart to Article 6. And they too, Massachusetts also did not consider their equivalent to Article 6 and its relationship to Article 83. Now they could be excused, I think, because they started amending their version of Article 6 very early in their history, and they amended several times. Gosh, the Massachusetts Constitution has been amended so many times in so many ways. So they could be excused for not realizing that there was a relationship between the two at the time. That's a McDuffie decision. McDuffie. And so our court's reliance on McDuffie to justify Claremont was misplaced for exactly the same reason. That they despite the length of the Massachusetts decision, despite its multitude of footnotes and all that impressive research, they did not examine the key question, which is how education was intended to be kept local but subject to coercion from the state to provide it.
Do you guys have any detail about who was behind it? That was part of that question. Was there an organization or anything that was going around doing that kind of litigation or encouraging it?
Well, the answer to the original question is it's kind of a mixed bag. So a lot of states went the kind of the Claremont route. New Jersey went. I do remember they did issue an order to their legislature to provide funding, but others have drawn back. Illinois drew back. I don't know whether they regressed later on, but Illinois rejected the idea that the court should take over from the give and take of the legislative process. So it's a.
I remember Kansas City. There was an infamous or famous case in Kansas City where the court took over a school district and it didn't turn out well.
Yeah. Now other states too also have constitutions that are different from ours. Ours, as I said, and I feel the Supreme Court didn't understand that the mindset at that time our Constitution was adopted was that education they wanted it to be local. They didn't want state funding of education because that would lead to state control. They understood that pretty well. But other states, probably farther west, when they did their constitution making, may have put different assumptions and beliefs into their constitutions, which would have made their school funding cases come out different in a way that could be defended more easily than Claremont can be here.
So I'm going to do the last question so we can end this. And by the way, it doesn't mean you can't ask another question. I just want to say it's the last one I have here. This one here, I want to ask you sort of the same way as the last of your interview or your presentation, Greg, and that is, there is the Claremont Reader. What else do you recommend for legislators in particular, or the public? What else do you recommend? I mean, I'm going to make, if it's okay with you, I'm going to make it available through a link or something to me. People can just read all that stuff you pulled together. And I assume that's okay, if it's okay with you.
Well, Ed Mosca wrote an excellent law review article, which was published in the Franklin Pierce Law Review some years ago. I think I have that so that I could email it.
I got it off. It's still there at Franklin Pierce. You can get it there. It's in their archives. But that's all in your reader. Is there anything else, or you know the
I don't-
reader?
I don't
You know the
I do.
content of the reader?
I don't think that's in the reader, is it?
Yeah,
At
it is.
Moscow's? Oh, it is?
yeah.
Or maybe I just found it separately, but it's easy
No,
to find.
I think I saw it in the reader, though.
I didn't
I
know.
think I saw it yesterday. The reader saw it. I could be wrong. There was something. Did he do two things?
I don't think
maybe
I
it's one
found out
missed.
about that for some years afterwards, but I'll see.
Yeah, well,
But
maybe you added
I
it,
do
yeah.
have that. It was, excellent.
Did you have any?
I
anything
mean, I
else?
just think you have to be familiar, really read the decisions with a critical eye. And so you have to sort of be micro and macro at the same time
Yeah,
to really get
yeah.
a feel of what's going on. Because the broad picture, I think, has gotten lost in a lot of the attention people pay to the details. And
You mean like the money itself and all that stuff?
well, there's the money itself, and just, how did we get here from Cherish? What are the steps that take us from a constitutional
Recommendation?
or urging of legislators, a list of things. These are the things that we, as the people who put down this government, think are important for you to consider as legislators, to a situation where we're now appealing a decision by a Superior Court judge who identifies to the penny what education costs, and the idea that whether it's cherishing or adequacy or excellent can be determined, can have a dollar value attached to it.
Yeah. You have a comment? Yeah.
I wonder how Judge Ruoff is rooting in this matter. I feel sorry for Superior Court judges that are going to have to deal with stuff like that. He must hate it. I would think he would hate it.
I like the big picture is an art thing,
There you go.
I like it. I like that as a matter of an ending for this, but we all need to be keeping that in mind. But the big picture to me is that this is New Hampshire's a republic, and the dominant power, in my view, simply ought to be the people. And if there's not judicial review by this general court, the ultimate say is, well, I'm sorry, guys, we're not going along with this. I'm troubled that we're not in a republic anymore. So that would be the way I would end a conversation like this. But I want to make sure everybody has a chance to say something. Any other questions or thoughts? Anybody? Good. Thank you guys so much.
All right.
Very much. Thank
you very
Rick.
much.
Thank you so much.
Thank you.
See you.
Hey, Greg, this is going to be probably the only one we do with a crowd, and this is so we could be in the Up and Walker house.
I didn't know what to expect. I thought maybe there'd be 100 people here. I'm glad there weren't.
If you're as concerned as we are with the loss of the legislature's control over policy and taxation in New Hampshire and wish to help, please share these podcasts with as many people as you can, and then consider donating so we can bring you and your friends even more of the important facts concerning our Supreme Court's Claremont decisions. And stay tuned. We expect to have more guests soon.